Max Elliott is here to talk about a little bit how we can make sure that our wishes are met. Max is actually, I took one of her courses a few years ago in doing my continuing education, and I remember thinking I have to bring her to the Dramatists Guild to share everything. She actually works out of Illinois. Or Illinois, I should say. Her law firm is the law offices of Max Elliott. She has offices in New York and in Chicago. She's the managing attorney there and the founder of her firm, where she really focuses on estate and business planning and estate administration. Their office primarily focuses on unique families, including members of the LGBTQ plus community, women, small business owners, and multinational families. She's pretty cool. She was actually inducted into the Marquis Who's Who in America in 2021. She was the first African-American member of the executive committee for the Chicago Bar Association's Trust Law Committee. She was also the legislative liaison for Illinois and a member of the Chicago Estate Planning Council. And as a member of the Illinois State Bar Association's Trust and Estates section and working group on electronic wills, she actually assisted in drafting what became known as the Illinois Electronic Wills Notary Act. Once she joins us, she'll provide us with a whole bunch of information, but just keep in mind that while she is an attorney, she's not anybody's attorney here. So you should always feel free and should be encouraged to discuss anything you hear with your own personal attorney.
I do want to thank you and share as much as I can about estate planning, especially for LGBTQ plus individuals and families, especially with respect to intellectual property, and also really with respect to just the challenges that one will face. So so we're going to talk about some estate planning, what I want to talk about what estate planning is and what it isn't. Often people think that estate planning is asset protection, that is shielding one's assets from creditors and from maybe spouses or partners who know that you are about to win a Tony and therefore also want to kind of hook into the goodies. So estate planning is not asset protection, and asset protection isn't even available if you're involved in litigation. You've got collection agencies have your number on speed dial, or you've actually met with an attorney about leaving your partner. But it is available. And this is asset protection, which is different because it's about shielding your assets during your lifetime for yourself. It is available if you've just learned that you're being nominated for a Tony. You conduct like hazardous philanthropic missions in your spare time. So you kind of like fly jet fuel across the country to zones where there is climate change catastrophes. And you have about $5 million in liquid assets. So, but that's asset protection. It's available for you, protecting you from creditors during your lifetime. That's not estate planning. Estate planning is about protecting yourself in the event of severe illness or incapacity. It's about protecting your loved ones upon your death. So your chosen family, for example, protecting spendthrift beneficiaries. Those are like nieces and nephews and children whose pockets have holes in them as soon as they get a little bit of money or resources. It's also, especially with respect to LGBTQ plus individuals and families, it's about protecting your estate from hostile takeovers, right? If there are family members who are adverse to your relationship, who really never embraced your particular relationship and your family. And so estate planning helps to protect you and your loved ones from those individuals. It also provides you with an opportunity during your lifetime, even if you're severely ill or incapacitated, and also during your death, to continue your particular philanthropic endeavors. So estate planning really is about protecting your interests for yourself when you're incapacitated, and also protecting your interests for your beneficiaries upon your passing. So what about, I just talked about lifetime, right? And you've got your IP protected. It's protected via copyright or patent law. So you're like, why do I need anything else while I'm alive, right? So I just stated that in sickness and in health, basically, you need protection. So if you're severely incapacitated or even in the hospital, you need what we refer to as powers of attorney. So those are advanced directives, and they articulate your wishes regarding medical and non-medical care and comfort when you're incapacitated. So we've all been living this nightmare called COVID-19, right? And pre-COVID, I would talk with clients and say, all right, do you want to be placed on a ventilator in the event you're hospitalized? No. Do you want to be intubated? No. Well, as you can imagine, those decisions have currently changed. And so now, sorry, we're having a drag race. So now there are, those decisions have changed. It also is about long-term care and preferences and the options that you have that may be available to you, and really about you establishing for yourself in these directives what kind of quality of life you want in the event of incapacity. Advanced directives also allow you to designate who can visit you. If you have hostile family members or just folks you don't want visiting you, not necessarily because they're hostile, but because you want to actually focus on getting well, or your partner or your spouse wants you to focus on getting well. And you know this person is not going to be most suited for visiting while you are in that mode. So advanced directives are really, really important in that regard. But especially with respect to hostile family members or folks you don't want to visit, I've had it tested. There are instruments that you can use with a healthcare proxy or a healthcare power of attorney that would allow you to prohibit individuals from visiting you, for example, if you were in the hospital. Property powers of attorney, again, just like healthcare powers of attorney, where you can designate somebody to fulfill your intentions and wishes while you are hospitalized or recuperating. You can determine what kind of access and control they have over financial accounts, what kind of access and control they have over your digital assets, which are critically important right now, because especially for artists, if someone does not have the legal authority to access your digital assets and they go and do it, they're basically committing a crime. And so you want them to have that authority. Now, what that authority looks like is up to you. It can be as broad or as narrow as you want. Can they discuss things with your agent, right? Not in being an agent. Can they discuss things, for example, with your literary agent? Can they discuss things with your publicist? Can they enter into agreements with these individuals? So you can mandate whatever kind of encumbrances or loans that this person can be responsible for. And again, authorize or prohibit certain types of investments and money management strategies. Very critical to authorize and name prohibited fiduciaries. Again, name your chosen family, name who should act, name who should not act. professional colleagues. We just talked about a literary agent, a publicist. Are those individuals, should they be perhaps your agent under a property power of attorney, or should they perhaps have some kind of special fiduciary role? So those are the roles that, and how having advance directives can protect you during your lifetime. Upon your passing, so you have these protections available during your lifetime, right? But you make sure that you also memorialize what you want to happen upon your passing. Memorializing is key. What you want to do, one of the ultimate goals, is to help our stewards stay out of court. Help your executors, help your trustees stay out of court. So if the laws change, the trust purpose can be realized. Your intentions, and here I'm mentioning a trust, but your intentions can be realized as long as the drafting is flexible. So for example, I don't know if you know it, but there's a big lawsuit going on between Truman Capote's estate and Paramount Pictures because of the copyright issue. There is the copyright supposedly expired and then reverted back to his estate, which then puts it under the purview of his foundation. And in so doing, the foundation can then use the licensing and the material and the intellectual property with respect to Breakfast at Tiffany's however they want. However, Paramount is arguing, no, the license has not expired, and we only want to use it, and we are authorized to only use it for our desires, and that is for a film. So if Capote's lawyers had actually memorialized this, taking into consideration when the copyright would expire, authorizing and mandating that the trustees re-up the copyright or do something else with it to ensure that it can be used, the intellectual property could be used for other purposes, then this battle would be moot. So a will, a trust, is like one of the most important pieces you can write or publish. So for example, with Stieg Larsson, again, he was not gay, but he was in one of those challenging relationships a long time. He was committed to his partner for 32 years. And then all of a sudden there was sudden death. He died suddenly, and he thought he had a will written, but it wasn't witnessed. And that was decades before he even wrote The Girl with the Dragon Tattoo. And then he died, and now all his collaborator and partner of 32 years receives is the house. That's quite unfair, but that's all she gets because there was nothing else to memorialize what he wanted in terms of his intentions for her. So let's keep the stewards out of court, and let's make sure that our partners receive everything that we want them to receive, whether they're spouses or actually long-time committed but non-married partners. Now, some of you may say, hey, there's marriage equality. So what does being a member of the LGBTQ plus community have to do with estate planning now? We have marriage equality. Well, just really quickly, Scalia may actually haunt you because the decisions that led up to marriage equality. So we're talking US v. Windsor, we're talking Obergefell v. Hodges. Those decisions, well, Windsor was actually an estate tax decision, and Obergefell v. Hodges was a marriage equality decision, but both of them had stinging dissents that provided roadmaps for those who are opposed to marriage equality. And in fact, all of the case law that undergirds marriage equality is written in feminist jurisprudence. And we all know that feminist jurisprudence is under attack right now. And so Windsor was really not a case about equal protection as much as it was for the opposition, a case about states' rights. And so if the state actually gets to choose feminist jurisprudence and reproductive rights, then the states can actually legislate perhaps the undoing of Obergefell v. Hodges, which was a plurality decision, a la not a majority of the Supreme Court voted for it. So it actually, we're actually keeping an eye on that. So it's really important that we understand that marriage equality is not concrete nor set in stone like a lot of folks think it was. It is. So before marriage equality, the planning was really complex. Marriage equality provided a certain amount of financial pragmatism, right, for surviving spouses. There is the marital estate deduction. Surviving spouses get their inheritance tax-free. There are Social Security benefits. There are ERISA benefits, which I'll get to in a second. And so it was really important for the LGBTQ plus community to have marriage equality to be able to take advantage of these more than 1,100 benefits. Equally important, it was just the moral right, right? It was just morally important that relationships, LGBTQ plus marital relationships, were not stigmatized, that they were on par, that they had parity with cisgender relationships. Before marriage equality, complex needing was really was important and needed if the estate was taxable, if there was a long time committed partner, if the partnership involved children, and again, if there were hostile or greedy family members. So like I said, the threads of marriage equality are really important. And what I want to provide is just a couple of examples. So for example, if you are an unmarried young couple and you don't have any children, why do you need a last will and testament? Because if you have intellectual property, if you have drafts, if you have something that's out there being shopped around, a manuscript or something of that nature, and you unfortunately experience a sudden death, or unfortunately a death related to COVID, then it's important that you designate a special executor to be able to handle these matters. If, for example, you have a specific desire for your disposition of remains, families go to battle over this all the time. A last will and testament is the only instrument by which you can actually designate what you want with respect to your disposition of remains. And again, for beneficiaries that you have. With respect to if you're married, you can, like I said, with a trust, take advantage of the spousal marital deduction trust. And that way your spouse will receive everything that you would want them to receive tax-free. If marriage equality is undone, there are still mechanisms that one can use as long as it's stipulated in the instrument that this is what you want to use. So for example, the federal estate, the federal exemption, currently it's crazy high, like 23 million for a married couple. But then there are states where the exemption isn't that high. It's a little lower, like Illinois, where it's 11. But if marriage equality is undone, you want to take advantage of that because you don't want your spouse to incur an estate tax, which currently at the marginal level is 37%. So you want to protect those interests, and you also want to protect your spouse and protect make sure that there is a special fiduciary if your spouse can't handling your intellectual property. Let's say you're not married, but you have children. There are long time committed couples who are famous, who are not famous, who have been together and have had children. A last will and testament is the only instrument by which you can designate guardians for your child. And it's really important if you're unmarried and you're unmarried, you're an LGBTQ person, or even just unmarried, that you stipulate who you want to care for your child, and you make sure that they are eligible as you are creating and having this instrument prepared for you. Again, the special executor comes into play very much so with respect to your intellectual property. And then because you're not married, if there are hostile family members, they need to be expressly disinherited. So yes, my sister Nancy, my brother Jim, they shall not inherit from me or through me for purposes known to me, because if you do not do that, if the language is not there, if it's silent, then the court will presume that maybe you forgot, or maybe the lawyer forgot, and that opens up the door for challenges. So this is important, especially, like I said, for LGBTQ plus couples, because 9 times out of 10, especially if you're unmarried, your partner has no blood relationship to you. And if you have hostile family members, it's through that blood connection that state law is actually derived. And through that derivation, they can challenge an estate plan in court. So it's critical that this language be in there and be expressed. I've had clients say, that kind of makes me feel, but well, if that makes you feel uncomfortable, what makes you feel more uncomfortable? Your longtime partner not getting anything, or the fact that your brother or siblings who you haven't seen in 3 years and maybe send you a holiday card if the spirit is willing, get everything that you own, right? So we have to balance, you have to balance those decisions. The last thing that I do want to chat about really quickly is the SECURE Act. In 2020, the Setting Every Community Up for Retirement Enhancement Act was passed, and that completely unraveled the ability for estate planning, for estate plans that provided that partners who are not married could inherit retirement assets and stretch them over their lifetimes. It completely unraveled that. So now, unless you are an eligible designated beneficiary, you can, your partner, your beneficiary probably cannot take those assets like a SEP or an IRA or even a 401k and stretch it out over their lifetime. They have 10 years. And so if you have children, this is extraordinarily critical, because your children will have maybe a large sum of money at their disposal when they're not mentally prepared for it. Now, there is a loophole, though, for unmarried LGBTQ partners, and that is the partner can inherit if they are not more than 10 years younger than you. So therefore, it's a loophole, and it has to fit right within that loophole, or else we've got to do some very interesting planning, which I have actually unfortunately had to do for partners who don't necessarily fit into that loophole. And I do think that my time is up in terms of the presentation, but I'm going to check and see if there are any questions. And if there are, then maybe I can answer some. Okay, so will partners automatically be appointed guardian of my minor child? In generally speaking, no. You actually have to designate someone who will take care of your child. And guardianship does end when the child becomes age of majority. And the courts generally will look at the biological parent. So, for example, if you were the biological parent and your partner stepped in to be the second parent, but there was no second parent adoption, and you are not married, then there is a likelihood, unless it was done via our alternative reproductive technology, that the court will look for that biological parent. How can you be sure you'll be able to visit your partner in the hospital or assisted living facility? Your partner has to designate you as an agent or place you on what we call HIPAA forms, which allow your partner to receive medical information. In the age of COVID, there are special, if the facility is locked down, and they're not letting anybody in, then that facility needs to actually it needs to be on the advance directive that facility and the people in that facility can actually contact your partner using your device electronically. If it's just a next of kin issue, then you need instruments evidencing the fact that you are considering your partner next of kin for all purposes. So your partner really needs to be an agent, though, and that would get them in. Are living trusts good for LGBTQ persons? Yes. Actually, living trusts are one of the few probate avoidance mechanisms. And as you just heard me explain really quickly, you want to try to keep your estate. I always try to keep everybody's estate out of court. That's basically the estate planning goal. However, when you have hostile family members, when you have estranged family members, and you have a partner, a longtime committed partner, you want to provide for them. And the best way to provide for them and really try to make sure that plan or your estate doesn't go into probate is by placing it in what we call a revocable living trust. Some people call it a revocable living trust. Okay, when will the slides be available? Okay. I'll have Deborah send out the slides as soon as I can get them to her. And I think that's all of the questions that we have thus far, unless Deborah, you see any more, but I think we answered everything.
I think we answered it, and I'll answer that. The slides are actually up on our website for right now, so you can go get them right now on www.thedgcm.org. Somebody was asking me if they could save the chat. I unfortunately just don't know how. If you tell me to in the chat, I will. I'm happy to do that. You could also reach out to us. I'm happy to send you the links and all of that for any of our websites and program registration. Again, best place. Oh, that was the other question I was going to say. How do they reach you, Max? So there you go. Again, she's based in New York and Chicago. So anyone in those regions should feel comfortable. I mean, Max, would you take on people outside of those regions, or is that sort of not?
So yeah, so it depends on the assets and the issues involved. Trusts are driven by tax law, which is a federal issue, so we can take on trusts. Wills, as you know, are driven by state law, so I would have probably co-counsel. I have folks in California who I work with, so other jurisdictions. So they'd have to contact me, and we could talk about it, or I would refer them to amazing colleagues that I have. So, okay.
Okay, perfect. So screenshot that. But that will also be available if you need any of the resources that you see this week. Just feel free to to reach out to us. And oh, I see the chat won't let us copy. Well, I'll email you because now you've given me your email. Okay. So that's it. Thank you so much, Max.
Thank you.
I told you guys she was wonderful.
I am so sorry I was late, but you know, I got in and got you as the information that I could. And the slides, as a matter of fact, the slides that I am using now, I don't know if you guys got them. I may have sent them to you, but if not, I will send them to you and you can pop them up.
Okay, so we'll get the refreshed version to you guys soon. And if you have any questions about anything you're seeing, of course, reach out and we'll put you in touch with Max or try to answer them ourselves. So thank you so much. I hope everybody will join us tonight at 6. Again, we have Pulitzer Prize winning playwright Doug Wright and the wonderful artistic director and also prize-winning playwright Emily Mann talking with Paula Alexson of the McCarter Theater, and then that's at 6 tonight. And then tomorrow at 3, we have Eric Collieri from the Ransom Center to talk about documenting your legacy, so what to do with all the papers and the drafts and all that stuff clogging up your home office. Should you save it or not? So join us to find out. Thank you so much, Max.
Thank you so much for this opportunity.
I hope we can grab you again another time, because I think that I think as people think things through, more and more questions will come out. It's such an important topic.
It really is. Happy to answer them to you, and hopefully we can make this happen again. Thanks again for this amazing opportunity.
Absolutely. Okay. I'm going to try to save this chat, but otherwise we will see you all hopefully at 6.